Chapter 12, Law related to tourism investment and finance.
Rafael Valdez is a seasoned restaurateur who made his fortune via his two fine dining restaurants which he slowly owns in the financial district of Makati. But Mr. Valdez is still dreaming of bigger things. He would like to build a deluxe hotel, a retirement village, and a spa complex, and many more. On the retirement village, he was able to convince some friends and suppliers to invest over 100 million and a bank loan was secured for 200 million. The idea was to build 50 upscale retirement homes adjacent to his hotel north of Manila for the Japanese, Filipino-American, and European markets. Each unit would sell for 5.2 million and even before they could get the necessary permits. Mr. Valdez was able to sell 8 units already. He was warned by the Housing and Land Use Regulatory Board on the consequences of pre-selling without a permit. He promised the buyers to have all the units constructed by 2010. 1 year has passed by and no one has work had been done on the land of development aspect of project. Meanwhile, money invested by the partners and money received as sales were already spent on the new additional restaurants being built. Dr. Pacifico Morales, one of the Filipino-American retirees, has been inquiring about his unit and no one could give a definite answer. What are your impressions of this business venture? What violations did Mr. Valdez commit? What are his liabilities to the investors and buyers? This chapter deals with laws related to promotion, monitoring, and regulation for tourism investment and finance in the country. Basically, this will tackle the participation of foreign investors as well as incentives given to Filipinos in case they will invest in the tourism industry. Special laws are even created to address needs of certain sectors like the informal sector and the Filipino balikbayans, retirees, and senior citizens.
The first law is the Foreign Investments Act of 1991.
Republic Act 7042 as amended by Republic Act 8179 on March 25, 1996, also known as the Foreign Investment Act of 1991, provides the policies that foreigners can now invest in all activities and enterprises in the Philippines except those who covered in the negative list. When foreign investment in the Philippines is not covered or does not seek incentives under the Omnibus Investment Code, the foreign nationality or entity can ascertain the extent of allowable foreign equity in the enterprise sought to be entered into simply referring to the negative list and filling the necessary requirements with the Securities and Exchange Commission. Under the Foreign Investment Act of 1991, a foreign national or equity must determine the kind of enterprise sought to be entered into, whether the enterprise is a domestic market enterprise or an export enterprise. Application of the law. Case. Tan O-cheng, a Chinese resident and citizen, wants to try the air transport business in the Philippines. If you were the lawyer appointed by Tan O-cheng to put up this kind of business, what advice would you give him? As the lawyer of Tan O-cheng, I would advise him that he cannot engage into air transportation as a sole proprietor because of the constitutional limitation that the operation of a public utility like the air transportation business shall be granted only to the citizens of the Philippines unless he wants to be naturalized under the Philippine laws. Under the current situation, I may advise him to look for partners or incorporators to form a partnership or a corporation under Philippine laws. However, the information must be based on the limited 40% foreign equity by the reason of the constitutional limitation. Investment in transportation business on public utilities. For common careers such as the airline, land, and water transportation business, the operation of such involves public service shall be granted only to the citizens of Philippines or to corporations or associations organized under the laws of the Philippines, or at least 60% of whose capital is owned by such citizens. In other words, foreign participation is limited to only 40%. In addition, the executive and managing officers of the corporation or association operating a transportation business shall be exclusive to citizens of the Philippines. Application of the law. Virginia Perez, a Filipino citizen and businesswoman, wants to engage in a limousine and car service business. She wants to start a fleet of 10 cars. If you were the lawyer appointed by Miss Perez to set up this kind of business, what advice would you give her? As the lawyer of Mr. Virginia Perez, I would advise her that she may engage in the transportation business as a sole proprietor or look for partners to form a partnership or incorporators to form a corporation in accordance with Philippine laws. If she chooses to form a partnership or corporation, she must observe the limitation of foreign ownership, a maximum of 40% of total equity. Investment and travel agencies and tour operators. The above provides the limitation of foreign participation to 40% of purpose of accreditation and operation of a travel agency or a tour operator by the Department of Tourism. In addition, Memorandum Number 211 approving the 2006 Investment Priorities Plan of Tourism, which covers the travel agencies or tour operators, has been classified as preferred activities pursuant to the Article 29 of the Omnibus Investment Code. Thus, in order for a travel agency or tour operator to be entitled for registration under the Investment Priorities Plan, an applicant must satisfy the Board of Investment that he is a citizen of the Philippines. The applicant is proposing to engage in a preferred project listed or authorized in the current Investment Priorities Plan within a reasonable time to be fixed by the board. And the applicant is applicable of operating on a sound and efficient basis of contributing the national development or of the preferred area in the particular of the national economy in general. Application of the law. Mr. Francois Renault, a French resident and citizen, is interested in putting up a travel agency in the Philippines, specializing in European outbound tour packages. If you were the lawyer appointed by Mr. Renault to assist him in putting up this kind of business, what advice would you give him? Mr. Francois Renault cannot just put up a business on his own as a sole proprietor in the Philippines, as the formation of a travel agency is reserved only to citizens of the Philippines under the Omnibus Investment Code. I may, however, legally assist Mr. Renault in looking for partners or incorporators for purpose of forming a partnership or a corporation under Philippine laws. However, the formation must be based on the limited 40% foreign equity by reason of the limitation under the Omnibus Investment Code. Investments in hotels, resorts, and other accommodation establishments. Thus, in order for tourist accommodation facilities to be entitled for registration under the Investment Priorities Plan, an applicant must satisfy the Board of Investment that he is a citizen of the Philippines. The applicant is proposing to engage in a preferred project listed or authorized in the current investment priority plans within a reasonable time to be fixed by the Board. The applicant is capable of operating on a sound and efficient basis of contributing to the national development or the preferred area in the particular and of the national economy in general. Application of the law. Martha Soriano, a Baguio-based retailer and caterer, noted the severe shortage of hotel accommodation in the city, especially during the annual Panagbenga Flower Festival. She invited some foreign friends, Arthur Hewitt, an American retiree, and Rose Ann Gold, a German hotelier, to join and invest in her new business venture, the Mayflower Hotel. Based on the business plan prepared, the total capitalization needed for the 50-room standard hotel is $20 million. Martha is only capable of raising half of the total investment needed. What advice would you give to Ms. Soriano as she forms a partnership with the two foreign partners? For hotel investments, 60% of the capitalization should be owned by Filipinos. Thus, 12 million must be owned by Filipino. If Martha Soriano can only raise 10 million of the required total investment of the Mayflower Hotel, she can do one of the two things. Borrow 2 million from the bank or any other source, invite other Filipino investor or partner to invest at least 2 million. Either way, the required 60% Filipino ownership will be satisfied. Application of the retail trade law for restaurants and shops. The following sales transactions are exempted under the coverage of the Retail Trade Liberalization Act of 2000 are therefore allowed 100% foreign ownership participation. by a manufacturer, processor, laborer, or worker to the general public the products manufactured, processed, or produced by him if his capital does not exceed 100,000. By a manufacturer of his products in a single outlet, irrespective of capitalization, and in restaurants incidental to the hotel business. Application of the law. Mr. Chek or Teng, a Chinese resident and citizen, wants to put up a fine dining restaurant in West Avenue, Quezon City, specializing Macanese cuisine. If you were the lawyer appointed by Mr. Teng to put up his business, what advice would you give? As the lawyer of Mr. Teng, I would advise him that he has three choices. He may register as a single proprietor at the Department of Trade and Industry subject to the investment qualification as prescribed under the Retail Trade Liberalization Act of 2000. He may look for partners or incorporators and form a partnership or corporation under the Philippine laws. However, the formulation must be based on the limited 40% foreign equity as prescribed under the Retail Trade Liberalization Act of 2000. He may put up a restaurant incident to a hotel business in a West Avenue, Quezon City so that he will be exempted under the Retail Trade Liberalization Act of 2000. In this case, he may put up a joint venture with an owner of a hotel business to pursue his restaurant business.
The next law is tourism projects under the Build, Operate, and Transfer Program. So Republic Act No. 6987, as amended by Republic Act 7718, referred to as the BOT Law. It implements the declared policy of the state to recognize the indispensable role of the private sector as the main engine for national growth and development, and also provides the most appropriate favorable incentives to mobilize the private resources for the purpose. The coverage of the BOT law extended not merely to government infrastructure projects, but also to government development projects. The schemes recognized under the law is the build and transfer. So it is a contractual arrangement wherein the project proponent undertakes the financing and construction of a given infrastructure or development facility, and after its completion turns it over to the agency or LGU concerned, which shall pay the project proponent on an agreed schedule its total investment expended on the project, plus a reasonable rate of return thereon. Next is the build, lease, and transfer. So it is when a project proponent is authorized to finance and construct an infrastructure, and upon its completion turns it over to the agency or LGU concerned on a lease arrangement for a fixed period, after which ownership of the facility is automatically transferred to the agency or the LGU concerned. Next is the build, own, and operate. It is a contractual arrangement wherein a project proponent is authorized to finance, construct, own, operate, and maintain an infrastructure or development facility from which the project proponent is allowed to recover its total investment, operating and maintenance costs plus a reasonable return thereon by collecting tolls, fees, rentals, or other charges from facility users. Next is the build, transfer, and operate. So it is when the agency or the LGU contracts out the construction of an infrastructure facility to a private entity such that the contractor builds the facility on a turnkey basis, assuming cost overruns, delays, and specified performance risks. Next to the BTO is the contract add and operate. So it is when the project proponent adds to an existing infrastructure facility which it is renting from the government and operates the expanded project over an agreed franchise period. Next is the develop, operate, and transfer. So it is when a favorable conditions external to a new infrastructure project which is to be built by a project proponent are integrated into the arrangement by giving that entity the right to develop adjoining property and also enjoy some of the benefits the investment creates, such as rent values or higher property. Next is the rehabilitate, operate, and transfer. So an existing facility is turned over to the project proponent to refurbish, operate, and maintain for a franchise period, at the expiry of which the legal title to the facility is turned over to the government. Lastly, rehabilitate, own, and operate. So an existing facility is turned over to the project proponent to refurbish and operate with no time limitation imposed on ownership, as long as the operator is not in violation of its franchise, so it can continue to operate the facility. An individual, partnership, corporation or firm, whether local or foreign, including joint venture or consortia of local, foreign or local and foreign firms, subject to the limits herein set, may participate or apply for pre-qualification projects covered under the provisions of the Act. On January 9, 2001, the Metro Manila Development Authority or the MMDA requested Truckworks to dismantle the billboards in conformity with the MMDA Regulation number 96-2009 prohibiting the posting, installation, and display of any kind or forms of billboards, signs, posts, streamers in any part of the road, sidewalk, center island, posts, trees, parks, and open space. Truckworks refused to comply and invokes its advertising contract with MRTC. Consequently, MMDA started dismantling the billboards and streamers of Truckworks. Does the MMDA have the right to dismantle the billboards and streamers of Truckworks? No, the MMDA has no authority to dismantle the billboards and streamers of Truckworks. The contract with the MRTC vested it the exclusive right to undertake advertising and promotional activities of the MRT structure. What is involved here is not an indiscriminate posting and installation of commercial advertisement, but one sanctioned by a contract under the BOT law. Applicable negotiable instruments and documents of the title. By way of introduction, the laws applicable for purposes of discussion of the different negotiable instruments and documents of title in tourism investment are Act 2031, also known as the Negotiable Instruments Law, the Presidential Decree number 115, providing for the regulation of trust receipts transactions, and the Warehouse Receipt Law or Act 2137. Some negotiable instruments and documents of title which can be useful in tourism financing and investment are the promissory note, the bill of exchange, and the check. First is the promissory note. It is a written promise committing the maker to pay the payee a specified sum of money. So there are two special types of promissory notes. First is the certificate of deposit. It is a written acknowledgement by a bank of the receipt of money on deposit which the bank promises to pay to the depositor. The second type is the mortgage note. It is an instrument by which the borrower gives the lender or the mortgage a lien on the property as security for the repayment of a loan. The next document that is useful in investment and financing is the bill of exchange. So it is an unconditional order in writing addressed by one person to another signed by the person giving it. So the types of bill of exchange are the draft. So it is defined as an order of payment of money. Next is the trade acceptance. It is a bill of exchange drawn by the seller and the buyer of goods sold and accepted by such purchaser of goods. And lastly, banker's acceptance. So it is a bill of exchange of which the acceptor is a bank or banker engaged generally in the business of granting bankers acceptance credit. The last document of title that is useful in tourism financing and investment is the check. So it is a bill of exchange drawn on a bank payable on demand. So there are special types of check, and these are the manager's check, the traveler's check, the certified check, and the crossed check. Credit cards. A credit card is defined as a small card establishing the right of a holder to credit a certain purchases such as meals, lodging, gasoline, or merchandise. It is a wallet-sized identification card that enables its holder to buy products and obtain services on credit from one or a variety of business firms. The Access Devices Regulation Act, or the RA 8484, seeks to protect the rights and defines the liabilities of parties who deal in credit cards and other access devices. Under the said law, any application to open a credit card account under an open-end credit plan or solicitation to open such an account either by mail, telephone, or other means shall disclose in writing or orally the following information, the annual percentage rate and the other fees, or the Section 4 RA 8484. In this regard, the credit card issuer must provide to the extent practicable a detailed explanation and a clear illustration of the manner by which all charges and fees are computed. Application of the law. Mr. Harry Ford, a computer wizard, was able to hack into the computer system of E-Bank of the Philippines. As a result, Mr. Harry Ford was able to transfer all of the money deposits of Mandarin Hotel at E-Bank of the Philippines in his name. Discuss the liability of Mr. Ford. Mr. Harry Ford will be liable for the separate crimes of theft under the revised Penal Code and hacking under Republic Act 8792, or also known as the Electronic Commerce Law.
Special Economic Zone Act of 1995. The law. The law provides for the legal framework and mechanism for the creation, operation, administration, and coordination of special economic zones in the Philippines, creating for this purpose the Philippine Economic Zone Authority and for other purposes. The PIEZA shall consider for registration tourist-oriented enterprises to be located in PIEZA-registered tourism development zones, tourism estates, which are enclosed by the DOT as enterprises that will be established and operated with foreign tourists as primary clientele. Application of the law. Case. Republic Act 7922 was enacted establishing the Cagayan Economic Zone. Accordingly, any foreign investor who establishes a business enterprise within the zone and who maintains a capital investment of not less than 150,000 pesos shall be granted a permanent resident status within the zone. Such foreign investor shall have the freedom of ingress and egress to and from the zone without need of any special authorization from the Bureau of Immigration. Legal opinion. Such law is constitutional in accordance with the state policy which provides the state recognizes the indispensable role of the private sector, encourages private enterprises, and provides incentives to needed investment. This law providing for the legal framework and mechanisms for the creation, operation, administration, and coordination of special economic zones in the Philippines will promote the flow of investors, both foreign and local, into special economic zones which would generate employment opportunities and establish backward and forward linkages among industries in and around the economic zones. In addition, these special economic zones shall be vested with the status of a separate customs territory which shall be within a framework of the Constitution and the national sovereignty and territorial integrity of the Philippines. Business models. The law. Joint venture. In a joint venture, which is similar to partnership, two or more persons bind themselves to contribute money, property, or industry with the intention of dividing the profits among themselves. To constitute a joint venture, there must be an agreement to enter into undertaking in objects of which parties have community of interest and common purpose in performance, and each of the parties must have an equal voice in the manner of its performance and control over agency used therein, though one may entrust performance to others. A joint venture is distinguished from a partnership in such a way that a joint venture may or may not attain a juridical personality. If qualified as a partnership under civil code, it is taxable as a corporation, and if not qualified as a partnership, it has no juridical personality. The legal concept of the joint venture is of common law origin. It has no precise definition, but it has been generally understood to mean an organization formed for some temporary purpose. It is hardly distinguishable from the partnership since their elements are similar: community of interest in the business, sharing of profits and losses, and a mutual right of control. Application of the law. Case. The country's largest property developer, Ayala Land Incorporation, will transfer the legal title of its 7,377 square meter property at Ayala Center in Makati City to KHI Ali Manila Incorporation, the joint venture company it formed with Dubai-based hospitality group Kingdom Hotel Investments Incorporation. Ali said that the property is valued at 1.76 billion pesos. The property is currently being used by Anson's department store, Park Square 2, and the public transport. The assigner is the registered owner of a parcel of land located at Ayala Center, Makati City, which it intends to convey and assign to the assignee, for the purpose of enabling the assignee to develop thereon a mixed-use residential and hotel condominium project. Discuss the possible benefits which may be derived by both parties in the joint venture. Legal opinion. The parties may declare the joint venture project as an investment priority plan and may apply at the Board of Investment for fiscal incentives, as the hotel project will help tourism in the country. It must be noted that the tourism industry and related projects such as hotels continue to be among the top foreign exchange generators contributing to the growth of the Philippine economy.
Financing. It is about the role of banks. The term bank generally is a corporation formed for the purposes of maintaining savings account and checking accounts, issuing loans and credit, and dealing in negotiable securities issued by governmental entities and corporations. Banks earn money by investing their customers' deposits. In order to protect the customers against loss, banks are strictly regulated by the Bangko Sentral ng Pilipinas. Before granting a loan or either credit accommodation, a bank must ascertain that the debtor is capable of fulfilling his commitments to the bank. It is customary in all banking institutions to execute a credit investigation report wherein it will provide the bank with facts to determine whether the applicant is financially qualified to be given a loan accommodation. The credit investigation report is considered an internal confidential document which must not be furnished to the client. The commercial documents which are usually necessary and required in the processing of loan availment in favor of the borrower or the corporation are the promissory note, the credit line agreement, the real estate mortgage, judicial mortgage, the surety agreement, the letter of credit, and the trust receipt. As part of the regulation of the government, the bank, a person extended credit, must give the borrower in writing a recital of the following upon extending a loan: the cash price, the amount credited if on installment price, the difference between cash and installment price, and the recital of finance charges, and what these charges bear to the amount to be financed in percentage.
Franchising. A franchise is a privilege given to dealer by a franchise service organization to sell the franchisor's products or services in a given area, with or without exclusivity. Such arrangements are sometimes formalized in a franchising agreement, which is a contract between a franchisor and a franchisee wherein the former may offer consultation, promotional assistance, financing, and other benefits. The franchisee must pay a franchise fee for such right. In addition, the franchisee is typically required to use the franchisor's product.
A franchise is a license from the owner of a trademark or trade name permitting another to sell a product or service under that name or mark. More broadly stated, a franchise has evolved into an elaborate agreement under which the franchisee undertakes to conduct a business or sell a product or service in accordance with methods and procedures prescribed by the franchisor, and the franchisor undertakes to assist the franchisee through advertising, promotion, and other advisory services.
Application of the law. Case. Joanne Perez is an entrepreneur who wants to have a restaurant of her own. After scouting for a couple of months, she decided to approach Pancake House for franchising. However, she wanted to incorporate some personal concepts in the restaurants that will, in effect, alter drastically in the true concept of Pancake House. Can Joanne modify drastically the business concept of Pancake House? Legal opinion. No. Joanne cannot modify the business concept according to her wishes. When she decided to acquire a franchise of Pancake House, she was essentially buying one whole system that has been tried and tested in the market. Drastic changes implemented can result in violation of the franchise agreement between the two parties. Taxes. Generally, Active business income earned by individuals is subject to graduated rates of tax between 5 to 32%. Personal exemption is granted to single individual or married individual judicially decreed as legally separated with no qualified dependents, 20,000 pesos, head of family, 25,000 pesos, and married individual, 32,000 pesos. There is allowed an additional exemption of 8,000 pesos for each dependent not exceeding 4.
The active business income of corporations, on the other hand, is subject to a flat 35% rate. Passive income such as interest, royalties, and dividends are subject to final withholding taxes which are withheld at source. The applicable rates of final withholding tax vary depending on the type of income involved and the taxpayer.
Mr. von Bach is a German operator of a German international carrier doing business in the Philippines. The data that follow do not include percentage taxes. How much income tax must Mr. von Bach pay? Legal opinion. Mr. von Bach must pay 12,500,000 pesos. Gross revenues from Philippine source 500 million pesos. Multiplied by 2.5% is 12,500,000 pesos. Value-added taxes. A 12% value-added tax is imposed on any person who in the course of trade or business sells, barters, exchanges, leases goods or properties, renders services or engages in similar transactions and who imports goods. Percentage taxes. Persons whose annual gross receipts do not exceed 550,000 pesos are exempt from payment of value-added tax but shall pay a percentage tax equivalent to 3% on quarterly sales. Domestic carriers and keepers of garages shall pay 3% of their quarterly gross receipts. International air carriers and shipping carriers doing business in the Philippines shall pay 3% of their gross quarterly receipts. Excise taxes. Excise tax is imposed on certain specified goods manufactured or produced for consumption in the Philippines for domestic sale or consumption or for any disposition and those imported. Customs and import duties. Customs duties are taxes on imports or exports. Travel taxes. Under Presidential Decree No. 1183 as amended by PD 1205, Batas Pambansa 38 and Executive Order 283, Filipinos and other nationals traveling to other countries are required to pay travel tax before departure. Duty-Free Philippines. Duty-Free Philippines is a duty and a tax-free merchandising system in the Philippines created to generate foreign exchange and revenues for the government. The Department of Tourism, through the Philippine Tourism Authority, was authorized to establish said system. Barangay Microbusiness Enterprise Law. Barangay Microbusiness Enterprise refers to any business entity or enterprise engaged in the production, processing, or manufacturing of products or commodities, including agro-processing, trading, and services, whose total assets, including those arising from loans but exclusive of the land on which the particular business entity's office, plant, and equipment are situated, shall not be more than 3 million pesos. All BMBS shall be exempted from income tax for income arising from the operation of the enterprise. The local government units are encouraged either to reduce the amount of local taxes, fees, and charges imposed or to exempt the BMBE from local taxes, fee, and charges. The BMBEs shall be exempt from the coverage of the minimum wage law provided that all employees covered under the Act shall be entitled to the same benefits given to any regular employee such as Social Security and health care benefits. Application of the law. Case. Mrs. Ninita Anaidas wishes to put up a resort in the city of Muntinlupa under the name Nits Garden and Swimming Pool. She has a capital of 2.5 million pesos for the construction of the swimming pool and other improvements therein. She wants to legally put up her business without going through expensive registration fees and subsequent expenses for labor benefits. Does her business qualify for the BMBE law? Legal opinion. Yes, it is definitely advisable for Mrs. Naidas to register as a Barangay Microbusiness Enterprise Act of 2002. A registered BMBE shall be exempted from income tax for income arising from the operation of the enterprise. In addition, a registered BMBE shall also be exempted from the coverage of the minimum wage law. In this regard, registration shall be valid for a renewable every 2 years. A registration fee not exceeding 1,000 pesos shall be paid to the local government unit concerned.